Welcome to The Explainer. Today we're diving into a classic homeowner dispute. One of those situations that seems totally simple on the surface, but when you dig in, it reveals a huge legal lesson about what it really takes to win a case. So picture this. A pipe bursts in a shared wall, or a flood from upstairs starts leaking through your ceiling, damaging your property. You pull out your HOA agreement, and right there in black and white, it says they are responsible for maintaining that common area. Seems pretty straightforward, yeah? You figure they'll fix it, no questions asked. It's an open and shut case. But what if it's not that simple? What happens when being technically right just isn't enough to get the job done? Now, this isn't just some hypothetical. We're going to walk through the actual legal documents of a real case. We're going to find out exactly how a complaint that seems so clear-cut can completely fall apart when it's put under legal scrutiny. All right, so first things first, let's just lay out the basic facts. What exactly happened here that was enough to spark a full-blown legal battle? So here's the deal. The situation kicked off with a flood in the apartment right above Mr. John Klemmer's place. That flood caused damage to the space between the floors, his ceiling and the subfloor of the unit upstairs. Now, here's the important part. According to the HOA's own rules, that space is defined as a common area, which puts the responsibility for it squarely on them. But when the HOA didn't make the repairs he thought were needed, Mr. Klemmer took the next step and filed a formal petition.
Okay, so that petition led to an official hearing. This is where both sides got to lay their cards on the table, and it's where the real heart of the conflict comes into sharp focus.
So on one side, you have John Klemmer. He comes in with photographs showing the stained subfloor and a sewer pipe. His argument is that the wood is damaged and it needs to be totally replaced. He's worried about mold, about bacteria. Then on the other side, you have the HOA. And interestingly, they don't even argue that they're responsible for the area. They admit that. Instead, they bring in a licensed contractor. And this contractor testifies that, look, the discoloration isn't structural, this kind of staining is pretty common, and hey, we even offered a fix. We offered to brace the wood, but Mr. Klemmer turned us down. So what do you do with that? You've got pictures versus the testimony of an expert. You have a homeowner's very reasonable concerns up against a contractor's professional opinion. How does a judge in a legal system even begin to weigh these two things against each other? Well, this is where the whole case pivots on a really central legal idea. See, it's not about the judge just picking the story they happen to like better. It's about one side having to meet a very specific requirement. It's called the burden of proof. In a civil case like this one, the person who brings the complaint, in this case, the petitioner, Mr. Klemmer, is the one who has to prove their side of the story. The HOA doesn't actually have to prove they're innocent. Mr. Klemmer has to prove they're responsible for the specific things he's claiming. And he had to prove it by a preponderance of the evidence. Now, that's a key legal phrase. It basically means his evidence had to be more convincing than the other side's. It had to convince the judge that his version of the story was, and I'm quoting here, more probably true than not. Think of it like the scales of justice for real. To meet this burden of proof, you can't just make the scales even. You have to actually tip them in your favor, even if it's just by a tiny little bit, more than 50%. So Mr. Klemmer made his claim. The wood must be replaced. He presented his proof, the photos. The big question is, was that proof enough to tip that scale? So that's the crucial point, isn't it? Did Mr. Klemmer's evidence successfully tip those scales past that 50% mark? Let's take a look at exactly how the judge saw it. The judge really broke this down piece by piece. His concern about mold and bacteria? Totally understandable. But he didn't bring any tests or any real evidence to show there was a level of mold that legally required a fix. The photos? Yeah, they definitely showed staining, but they didn't prove the wood was structurally ruined and had to be replaced, especially when the HOA's own expert said it wasn't. And that pipe? There was no proof at all that it was actually broken or malfunctioning. And that brings us to the judge's final conclusion, which really just gets to the absolute heart of the matter. It wasn't a question of whether the area was damaged at all. It was about proving the damage was bad enough to demand the specific, costly repair of a full replacement. And this is the tiny detail that the entire case turned on. Showing that there's damage is one thing. Proving by a preponderance of the evidence that a specific fix is legally necessary, well, that's a much, much higher bar to clear. His photos proved there was a stain, absolutely, but they didn't prove that he needed a total replacement over the HOA's much simpler offer to just brace the wood. All right, so with that established, let's get to the final outcome and see how this decision was made official and legally locked in. Because Mr. Klemmer failed to meet his burden of proof, the judge's hands were tied. She had to rule against him. The petition was ordered to be dismissed completely. And the story doesn't just stop there. The judge's decision was sent up to the state agency, which had about a month to look it over or maybe even change it. But that deadline came and went. No action was taken. And with that, the judge's order was officially certified. The case was over. For good.
So what's the big lesson here for all of us? I mean, Mr. Klemmer was right in principle, right? The HOA was responsible for that common area. But in a court of law, being right on principle sometimes just isn't enough. You have to be able to prove your specific claim with evidence that is stronger than what your opponent brings to the table.
And that really leaves us with a pretty critical question to think about. In our own lives, when we get into a disagreement, how often do we actually stop and think about the difference between what we know is true and what we can actually prove is true to somebody else? Because as this case shows, the answer to that question can make all the difference in the world.